You are now listening to the Fighting Back Podcast, and here's your host, Jessica Travis. Welcome back to a brand new episode of the Fighting Back Podcast. This is a Sidebar episode entitled Technology, Friend or Foe. Jessica, how you doing?
I am good. Okay, so before we talk about technology, which may be fun or not, let's talk about something that's really fun. How's the wedding planning going?
I thought I knew how much a wedding was going to be. Apparently, no. It's an ever-changing number because the guest list keeps going up. We have a new idea. She saw something on Instagram, and social media is hurting me because we have a folder that we share on Instagram where she's constantly like, check this out. This is a good idea. We should contact this person.
And you know the algorithm knows you guys are getting married, so like all you're doing is getting those like sponsored content.
I get puppy videos and wedding videos in my algorithm now,
Yep.
So my algorithm knows me. But yeah, technology has actually been a foe for me for the wedding planning, but it's also a foe for a lot of people when it comes to their cases. And I got a couple of questions for you, Jessica, regarding how social media and AI could affect a case. You ready for this?
I'm ready.
All right. So the very first one. Can social media really be used against someone in court?
Oh, yeah.
Really?
Yeah.
How so?
So the rules of civil procedure and the Florida rules of family law allow for very general discovery in litigation cases. So in family law cases and say in personal injury cases. So they allow the parties to obtain discovery regarding any non-privileged matter that's relevant to the subject matter of the action. And these rules specifically allow electronically stored information. That is allowed. So electronically stored information can be social media. It can be the metadata behind social media. It can be all of those type of electronic information.
So, and these rules are constantly changing because I'm sure that rule didn't apply 25 years ago when we didn't have social media, right?
Very true. The rule was amended, I think probably 10 years or so ago to add in electronically stored material. But what the rules do is the courts have been interpreting them this whole time. So as technology changes, the litigants in cases are asking for discovery. They're asking for things in discovery, and the courts have to rule as to whether yes, you can have this thing that you asked for, or no, you cannot. So in these litigation cases, specifically in PI cases, criminal cases, family law cases, one side has been asking for social media discovery and technology discovery, and courts have been allowing them to have it.
And once that subpoena and order is signed, like they are obligated to hand that information over, right?
Yeah, so there's two different ways that this discovery is happening. So the first is in the personal injury and family law cases, there's a lot of reciprocal discovery, which means if you and I have a case against each other, I ask you for certain documents and certain information, and then you have to give me those documents and that information. In a criminal context, while there isn't reciprocal discovery in that sense, so the defendant doesn't necessarily have to provide a lot of the discovery, law enforcement uses subpoena power in order to get that information directly from the source.
Ooh, okay. So, all right. Ooh, this is a good one. I don't know how your social media is. Mine's open. Mine, everyone can see it. I got nothing to hide. But there are some people who have private accounts, and if my account is private, am I safe?
The answer is not necessarily. So I would definitely recommend having a private account versus a public, just because if an account is public, you know everybody can see everything, to be aware of that. But even if an account is private, you're not necessarily safe, because a court can still order that you give all of that information to the other side, or a law enforcement officer can still subpoena all of that information from the carrier. So just because an account is set at private doesn't mean it can't be accessed by the other side.
Ooh, okay. All right, so the next question coming up is, how does social media impact divorce cases?
Yes. So In family law cases, the courts have recognized that social media can be disclosed and is discoverable. They do have a balancing test to make sure that, there's privacy requirements and that the requests aren't too broad or insufficiently justified. But, for example, in a divorce case, and I'm making these facts up. But if you had a situation where one person wanted more than half of the marital property, we call it unequal distribution.
Okay.
Because the other person had a person on the side, a girlfriend, boyfriend,
Ooh.
and during the marriage, and was spending all of their money on that girlfriend and boyfriend and kind of depleting the marital assets on that person during the marriage, then the non-cheating on spouse would ask for the unequal distribution of the marital assets.
Oh.
So social media can be used in order if, say, for example, that other person who was out gallivanting was posting on social media the trips to Aruba with their girlfriend or boyfriend, or the new yacht that they just purchased for their girlfriend or boyfriend, or something like that.
Yeah.
Those social media posts, those pictures, that data could be retrieved and then used against that person to show they had a person on the side and they spent all their money on the person on the side, and that's why they shouldn't be entitled to half.
So kind of reflecting back on a previous episode, and I want to see how this could affect. Let's go back to that Kiss Cam scandal from last year at the Coldplay concert. Could that single clip that was made public to everybody be used either by the spouses in those divorce cases?
Well, of course. I mean, and that clip is a little different because it's public, right? Everybody has access to it. We saw the picture of it.
Yeah.
But when we're talking about social media discovery, we're talking about, in the case that I'm talking about the trips to Aruba, the one party could ask the other one, you're required to disclose to me all photographs you posted on social media. So I knew you went on vacation at this time. You're required to give me all of the postings that you did on social media, or every place that you tagged. You tagged that you were on the beach in Aruba. You tagged that you were in this location. All of that, the metadata from your social media. So if you uploaded a picture, even if it's just a picture of some random beach, the metadata involved to say where that picture was taken and what was the geolocation of that picture.
Yeah. That, oof.
Yeah.
Be careful with what you post. And this actually goes along with this question right here. What about posting a new girlfriend or boyfriend during a custody fight?
Yeah. Again, I mean, it's the same type of thing. Social media and the posts that are in social media, even when your account is set to private, does not mean that they are not immune from being disclosed and the other party being able to use them against you.
Okay.
So anything that you post in any type of litigation case, I like to think of it and think on the side of no matter what you're posting on social media, like you need to assume that the other side is going to find out about it and try to use it against you. And think about when you're posting anything.
I feel like you are reading my mind because the next question was like, what's the right way to handle social media if you're in litigation?
So I would say the right way to handle social media in litigation is to not do it at all.
Say that one more time.
Do not post anything while you are in litigation. Don't post about the litigation. Don't post about the other side. Don't post about what you had for dinner. Don't post about the event that you just went to. Don't. You know what? Take this time for a social media cleanse. Embrace your mental health. Don't post on social media. And if you do, just know everything that you post on social media can potentially get into the hands of the other side and can be used against you.
And I think this one kind of just correlates with the previous question. But this one is, if I have an open PI case, should I continue posting on social media? I think that's basically the same question.
That is, absolutely. So in PI cases, I have noticed that a lot of times the defense attorneys try to use social media against people in different ways, in ways that you might not even expect. So, for example, if there is a client who is significantly injured in an auto accident and is explaining that they are in pain all of the time and that they can't move and they can't enjoy all of the family functions or their life like they used to because they're in pain, I have seen these defense attorneys that work for the insurance company get social media posts where they show innocent posts. They show them playing around, playing football with their family, tussling with the kids.
And that could be
like
seen
that.
as like, oh, they're not injured, they're fine.
And then they use that against the person to say, this person isn't injured. Look at them playing with their kids on the ground. Look at them playing football in the grass. And so they'll use that against them.
I feel like if I were to be in some sort of PI case, I think I would just have to go back to a flip phone because I'm constantly posting everything that I'm doing because that's just my demeanor. I love sharing with the world. But if I'm in an accident, I am going to a flip phone. We got time for 2 more questions, and I got one for you right here. This is in regards to a criminal case. What about deleting posts after being arrested?
Yeah, so that is a tricky situation I would not put yourself in.
Ooh.
So,
How so?
There are a lot of situations where a court can find that somebody was guilty of spoliation or of deleting evidence after the fact. So and that can lead somebody in very significant trouble, sanctions, things like that. So my advice to everybody is don't post in the first place, right?
Yeah.
Because if you do post something and then you're in litigation and you delete something, that could make it worse off for you. The better practice is just to not post anything on social media in the first place, as opposed to scouring your social media once you're in litigation and deleting everything you think might be used against you. Wouldn't recommend that. Could have some negative consequences to your case in the future.
Okay. And then the final question for today is, can prosecutors subpoena private messages?
So, yes. Prosecutors are able to subpoena a lot of information, and a lot of it depends on the purpose for it, the way that they legally go about subpoenaing the information, and then the purpose for it. So we have some cases where, moving on really from social media to smart speakers.
Okay.
We have situations where law enforcement actually subpoenaed smart speakers and used the information and the audio that was obtained from those smart speakers in a criminal case. This happened in Arkansas, in Florida, and in New Hampshire, where police are actually getting these smart speaker devices. They're recording, the smart speakers are recording the conversations and what's happening inside the home.
Technology is always listening.
Right. And then the police are using them in these murder investigations.
Wow.
Yeah.
That's crazy. And great information to know right there as we're wrapping up. If you get hurt, don't post. If you're in an open case, don't post, basically. Any final words that you want the listeners to hear from you before we head out?
Yeah, the last thing I want people to think about is AI. So the courts really haven't talked about AI and about your conversations with ChatGPT or with the other AI technology that we have so far. But think about it. Think about if you are on social media and that information isn't private. And even your smart speakers recording inside your home isn't private. Think about what you're talking to, your internet search history, your conversations with ChatGPT. And I really think the decisions are going to be made in the future as to whether or not those are private or whether or not those can be disclosed and to law enforcement and to opposing parties in litigation.
All right. Well, that being said, 407-344-4837, fighterlaw.com. If you have questions that you want answered on the show, go ahead and send it to us and send them to help@fighterlaw.com. That is it for us today. My name is Patricio, a.k.a. Rocky. Jessica, thank you so much for your knowledge and time, and we will see you later. Thank you so much for listening. If you found this episode helpful or informative, don't forget to follow us on social media and share this podcast with your friends. Like, follow, subscribe so you never miss a show, and help others know their rights by spreading the word. Your support helps us keep fighting back. The information provided in the Fighting Back podcast is for general informational purposes only and is not intended as legal advice. Every case is unique and should be reviewed by a qualified attorney who can provide guidance based on the specific facts and circumstances of your case. Listening to this podcast does not create an attorney-client relationship with Fighter Law or any of its attorneys. If you are facing any legal issue, we strongly encourage you to consult with a licensed attorney directly.